Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola Law Firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we have a very important program on making and breaking contracts. That little contracts, big contracts, just providing information about contracts and what you need to know. And our guest today is Elan Weinreb, and he's an attorney right here in Garden City, and he's also a commercial litigator. He's involved in ADR, which is Alternate Dispute Resolution, and he's very active in the Bar Association ADR programs. Elan, welcome back to Law You Should Know.
Thank you very much, Ken. It's a pleasure to be back. I want to start out by telling everyone that contracts in general is a very complicated area of the law, even though we run into it every day. In fact, some people say that the very existence in a system of government constitutes the consummation of a contract between the person and the government. That's the basis for the social contract, going back to some Enlightenment philosophy. But when we also look at contracts, we can sort of translate it from a legal standpoint, from being legalese, into practical principles. And that's my goal today. I want to explain to everyone in layman's terms how we can approach contracts from more of a down-to-earth perspective. And
a practical. It's Correct. Just important that people be aware of the basic concepts so to know when they're obligated to do something and when someone they're contracting for goods or services is obligated to provide those services.
Absolutely. So
tell us when we have a contract and how they come about. What creates a contract?
Okay, so just before we get into definitions, I want to give people some of the idea of sources to go to in case they want further study. There are two huge bodies of law with respect to commercial contracts, and that is the Restatement of Contracts, which is studied in law school extensively, and the other one is the UCC, the Uniform Commercial Code, the latter being more specific and usually applying to goods transactions, specifically in Article 2. So I'm not going to go through every single citation. I have some notes that I've made point by point in terms of giving sections, but just so everybody knows, that's the basis for a lot of what I'm saying. And if anybody has further questions, they could go to my website, www.weinreblaw.com, to get my contact information, and I could certainly answer questions about what we're speaking about today. All right, to get to what your question was, Ken, what is a contract? Well, a contract at the very base, if we want to talk about a simple definition, constitutes three things. It constitutes an offer, it constitutes acceptance, and it constitutes consideration. Now, you don't necessarily need to have that last element, consideration. I'm going to go through which each one of them is as we discuss the making of a contract. But for the most part, when we're talking about general contractual dealings day to day, consideration is there. What is that? And we're going to start with that. Consideration is what could be colloquially considered substance of bargain. In the legal world, it's known as bargained for legal detriment. Again, that's one of those classic.
And just to keep it simple, we're talking about perhaps money or something
Correct.
To be done in exchange.
Yeah, and we're going to get into the valuation of exactly what consideration is later on. But it's important because, as you pointed out, it's the substance of whatever the bargain is between the people. Now, going back to the other elements which you need in every contract, you need an offer, which is a manifestation of intent to make a specific promise. And then in addition to that, you also need an acceptance, which is a showing of intent to accept or to follow the guidelines of the offer in the manner in which it was given. So the courts actually have taken a lot of those elements of offer, acceptance, and consideration, and they've given essentially a very succinct but also detailed test. And this is what the Supreme Court of Westchester County said in 1988 in Masagli versus Bastis. It's been held that a valid contract requires a person able to contract, meaning you have to have the legal capacity and the ability to do it. A person able to be contracted with, that's the same thing. So party A and party B in colloquial terms. A thing to be contracted for, that's known as the object of the contract. A sufficient consideration is what we talked about before.
Some kind of exchange.
Exchange, exactly. You have to have some substance of bargain. It could be money. It could be forbearance, meaning that you don't want to sue. You also need, according to this court, clear and explicit words. We'll see that's not always necessarily the case.
There has to be sort of an agreement by both parties.
Correct. But where it gets complicated sometimes is that an agreement is not necessarily a contract.
So if someone makes a counter offer, let's say you're selling a car and you want $10,000, someone offers you $5,000.
You don't necessarily have a contract at that point.
So until both people agree on the terms going both ways?
That's right. There's a meeting of the minds. And that's the last element that you have from the Masagli case, the assent of both contracting parties. You need to have a meeting of intention. Otherwise, what ends up happening is that you don't have the requisite bilateral or equal mutual obligation that's put up by the parties. And in that case, the courts will not infer a contract if it comes to that.
So both people need to agree, both parties need to agree on the terms.
Correct.
And more or less on the exact terms.
Correct. And the terms should be rather precise. If you have an ambiguity or if you have a missing term, you can run into problems. Classic example, let's take your example that you gave before, the sale of a car. If a person says, I'll sell you this car for a reasonable price. Now, that could very well, depending upon the nature of the parties, be a contract, and it could very well not. Certainly, if a person says, I'll give you the car, and then afterwards the other person says, okay, I'll accept the car, that's the easiest example to distinguish between something which the law recognizes as not being contract, and that's a gift. That's easy. The gift is the antithesis, the opposite of a contract. And so, Ken, you're right. The terms have to be there, but it's not just that you have the terms, it's also that you have a specific offer, you have a specific acceptance, and you have that exchange, that consideration.
And sometimes you need some details about when it's going to happen, if there's any preconditions.
Yeah, absolutely. It's good in that aspect to distinguish that a condition is something which is distinct from a promise, even though they both involve temporal or time elements. A condition is something which does not necessarily give rise to a contract, but a promise will give rise to a contract as soon as something is stated. So, for example, and even, by the way, we should make a point, a lot of people think that contracts have to be in writing. They do not. In New York law, in the cases that we have, there are a lot of times where people have oral contracts, and they're perfectly valid.
And, of course, now there's questions about whether you can have a contract by email or text.
Yes. Well, in those cases, for the most part, courts have found that those modes of communication, because they can be reduced to a writing, you could always print them out, constitute a writing. So they're really, for the email contracts and text contracts, SMS and what else, are very much writing.
So you better be careful about agreeing to something via a text or an email. Now, what if someone... So I'm just saying, is that important for our listeners to understand?
Absolutely. If someone sends you...
It could be construed like as if you signed it or sent it to it.
Yes, absolutely. If you have manifested your assent to an offer, for example, someone writes, I'll sell you my car for $5,000, and you can put a condition in there, provided that you tender payment, you're able to tender payment within 2 days, and you respond back saying, I accept your offer and will tender you $5,000 by tomorrow, you got a contract.
And you may, about the condition of if you have concerns about it, you want to give details. Sometimes details are important.
Correct. So the condition that we spoke about before, just to give listeners an idea between the difference between a promise and a condition, you could put a condition in as random as, if it rains for 3 consecutive days, then I will give you $5,000, as you've said before. If for whatever reason it doesn't rain for 3 consecutive days, then there's no contract. You're out of the off the hook.
So it's important that all the terms, whether it's verbal or writing, be clear, be defined as to when and how it's the deal will take place.
Absolutely. But in addition to definition, and this is why a writing in particular is viewed as being superior in certain cases over a verbal contract or just an informal contract. And in that regard, I just want to give a quick example. You can even have a contract by implication. A person could walk into a supermarket, as most of us have done, and ask, is that the National Enquirer or whatever newspaper? The cashier can say yes. Person can see $1 written on the National Enquirer. There's no further words spoken. Person picks up the National Enquirer, plunks it down on the table. The cashier looks at him or her. That person then tenders $1, which was the price. The cashier takes the $1, gives the receipt, and says, "Have a nice day." There's a contract by conduct with very little words, but people have engaged in that all the time. The assent there is indicated through the conduct.
Or if you order food in a restaurant, you're more or less, it's presumed you're agreeing to pay their prices.
That's correct. And in fact, in ordering food in a restaurant, there are really two contracts that are involved at least. There's the contract which is involved by implication between you and the owners of the restaurant. And then, since most people pay by credit card, there's also the contract which is involved between you and the credit card company when you use your credit card, in that you're getting credit by the credit card company. That's that credit card's company consideration. They're lending you the money in exchange for your promise to pay on time, which is, or also for that matter, any applicable interest charges, which is your consideration. So
and if
you have
someone's ordering specials and the price is not given to you, you're presumed to be agreeing to whatever they are. Or if fish or something says market rate, presumably by ordering it, you're agreeing to that.
That's correct. Although there are some times when, we're going to get to this, I think, in the second part of the program, where the law allows you to get out of a contract or back out of a situation where one would be obligated. In the case that you just gave, if for whatever reason the fish is not to your liking, and you have not eaten, if I remember correctly, 75%, the other way around, 25% of the food, such that 75% or more is still remaining, you can then send that back and not have to pay.
But you also, the best practice might be to find out how much it is.
No,
or if you're being served water and it's coming out of a bottle, you might want to find out if that's included for free or is a charge for that.
Yeah.
Otherwise, it might be presumed you're agreeing to pay it.
Absolutely. In fact, it happened to me one time. I went into a restaurant and I saw on the menu market price, the famous abbreviation MP, and so happened to be lamb chops. I liked the way that the chef did his food in that particular restaurant. And at the end of the day, I ended up getting a bill for about $80 for the lamb chops.
Okay. So. we just have, I know there's a lot of information about contracts you want to convey, so we just have to move on. Anything else you want to say about consideration?
Sure. So consideration, as I said before, can be what's called a forbearance, meaning you could refrain from doing something. As a famous case that law students studied called Hamer versus Sidway, in which an uncle promised his nephew that if he quit drinking, smoking, swearing, playing cards, essentially a lot of vices, for money, he would give him, if he quit all of that, he would give him a substantial sum of money. That was $5,000. He had to do this until he reached the age of 21. Well, unfortunately, the uncle died without having paid his nephew, and then the estate turned around and said, well, there's not a contract over here. There was just this nice promise by a kind uncle, and we don't have to abide by it. But the courts, the New York Court of Appeals, is going back to 1891. This is an oldie but a goodie. The New York Court of Appeals said no. The case happens to be that the nephew decided to refrain from doing something which he had a legal right to do. He had a legal right to play billiards, to play cards, and to at that time smoke and what else. And because he decided to refrain from doing that, that was sufficient consideration. So you could have that as well. Okay.
Unfortunately, our time is limited, and we're going to cover breaking a contract in a few minutes. Anything else you want to say about making a contract?
Right. Also, with respect to the consideration, some people, have the idea that you have to have money. You don't always have to have money involved as part of a contract. As I said before, you could have a forbearance. But
or it could be an exchange.
Right. Or it could be an exchange of a good for a good, this particular item for another particular item. But the other thing about consideration is that courts very often will not scrutinize the value of the consideration. So you have a case, Kessler versus National Presto Industries, comes out of the Eastern District of Michigan, where a woman actually, this will go to your torts background, a woman actually released a pressure cooker manufacturer from liability, from products liability. She was injured, and she released them, basically said, you're off the hook for $750,
And I just want to say, if you're considering negotiating terms, or maybe it's a home improvement contract, if there's sufficient money involved, whether you're whichever side of the contract you're on, it's better to have them reviewed by an attorney.
Absolutely. I wouldn't say it's better. I would say it's imperative to have them reviewed by an attorney, because there are times when there are hidden defects and other traps that you